for them to finish bringing before we enter. Will you wait for them to finish bringing?
Of course, now the cars we are using them.
Okay. Okay, so let me lock this place.
Huh?
Let me lock it.
I'm going out now. I'm going to for this one is working out.
Okay.
Come on, my love.
Good.
Sir, go coffee. Thank you. Hey, go coffee room. Here you sit now.
Yes. Why is she now? Let her come out and come out.
Bring the coffee.
She needs coffee because she's more than this.
You know, should I call her to come up?
She's running down. Don't leave her. That's why I don't pass.
Okay.
Bring them out.
Bring them out. Yeah, see them on the floor.
What is the name of that one?
This one will be the 13183.
I see name.
What is that?
It's Lechi. It's one of them.
Carry on. What
What was that one?
this one?
Bring it. Let me bring it.
Carry this one.
What will have the Madam?
This one is asset management corporation of
No,
Nigeria.
no, that's it.
Get that one.
What was that?
This one is Mr. Emmanuel.
Peter Otava.
Then this one
British
is
Nigerian.
Peter Makai. Maudi.
Onyeri.
This
Favor.
one is Alamudi Adedayo. This one is
Asset. Okay. Let me see.
is that one is not.
This in God, Nigeria. This I saw this one.
What do you mean? Is this a top of anything? Hello, this one is here.
Okay, so
Yes, it's here. I
What's
just
your
collect
this
it now. Come.
Check this one.
Yes, what is good? We just remove it now.
See this one.
What's the name?
Green.
109.
You can use paper. Later we transfer the proceeds.
Okay, yeah. We just
Carry the one that are not here. We use. Yeah? Let's go.
Just leave her. Let her get
You said? No, I have given, this man has removed it from the bag now. Udo, that your second. Ask him, is there later? He told you that I say he should remove it. It's for today. Okay, I mean about.
Let's see, come and look.
Yes. Any counsel about. Let's go. Which one is that? Sit down. Good morning, counsel.
Good morning, my lord.
Yes.
Yes. What's the case now?
Resume today, Thursday, 7th of October 2021, before His Lordship Honorable Justice Ado Sanusi presiding. Suit number NICN CA 5610 between Mr. Okade and 4 others, and ASGS Integrated Service Limited. And 1. Guarantee Trust Bank PLC. 2. Zenith Bank PLC. 3. Heritage Bank PLC. 4. Access Bank PLC. 5. First Bank PLC. 6. First City Monument Bank PLC. 7. Keystone Bank. 8. Polari Bank. 9. Sterling Bank PLC. 10. United Bank of Africa. 11. Unity Bank PLC. 12. Union Bank PLC. 13. Fidelity Bank PLC. 14. Stanbic IBTC Bank PLC. 15. Eco Bank. My lord, parties are all absent.
Appearance?
This is my lord.
Yes.
E.L. Akpama.
E.L.
Akpama. Akpama is called
Akpama.
A-K-A-M-A. All affairs of judgment creditors applicant. Now we have before you a motion expert
Yes.
dated the second day of July 2021 and filed on the second day of July 2021.
You see, counsel,
Yes, my lord.
before we go far, I can make order nice against 15 banks, because I know that there was no way the defendants will have account with all these 15 banks. You have to narrow down to the banks where they have accounts,
My lord,
and you also have to provide the account number.
the problem with that, like even most of the judicial authorities, most of those information are confidential, and there is no way the applicant.
No, unless he is not a worker. As workers, they have friends there. They have in the account department.
They
Start
were
giving
working, they
them.
were not working with those banks. They were
Not
actually
with the banks, the defendants.
yeah, with the defendants.
Yes. They are defendant workers, so they should be able to access to get the account number from the office.
The banks, the major bank where you were receiving their salary was Zenith Bank. If you look at my lord, and all made an order concerning Zenith Bank specifically. And my lord, you look there now, the second judgment debtor is going to be the issue, because the judgment was against the first and second judgment debtors respondent.
Well, I have told you my mind, how my mind is working, so you should know. If you want to move, you can move your application. I don't want us to waste time. You have to do your homework. If you want judgment, I can't issue order to 15 banks. They are already on record, so they are parties. Unless you amend your process, remove them, amend your process.
I'm telling you.
Yes.
Names of other banks stock as part of the stock is present.
Recording in progress. Recording in progress.
No,
Recording in progress.
Oral application to strike out the partnership. Save the name of Zenith Bank is hereby granted as spread. The judgment creditor is to proceed against Zenith Bank of Nigeria PLC.
akwai matsala.
Why is it? Why is it there? Let me have you there. Is my ruling. I have carefully perused the motion ex parte, the affidavit in support, together with the two exhibits attached therein, and the written address filed in support of, along with the motion or not, along with the motion ex parte. I am satisfied from the deposition contained in the affidavit in support of the motion ex parte that the judgment creditor are entitled to enforce the judgment of this court via garnishee proceeding. In the circumstances, it is hereby ordered that 1. An order NISA is hereby granted in favor of the judgment creditors for the sum of 13,720,000 naira standing to the credit of the judgment debtors in their accounts with the Zenith Bank of Nigeria PLC to be attached. 2. The garnishee Zenith Bank of Nigeria PLC is hereby ordered to show cause by filing an affidavit why the order NISI shall not be made absolute. 3. The order NISI shall be served on the judgment debtor and the garnishee. This case is adjourned to 3rd of November 2021 for hearing of the garnishee proceedings. Call the next case. Yes.
Our matter, my Lord adjourned our matter today. And
Yes.
my Lord, we have I just informed my Benin friend on the other side before your little brother in that they should stand down my matter. My Lord, the matter that was adjourned for today was for report of service. My Lord adjourned the matter.
No, I adjourn it for ruling.
Yes, my Lord.
Not
My
report.
My Lord said it should be for report of, I saw report of service, my Lord, on the first.
No, unless you dictated to them, because that is not what is on the record. Why do you go and put for report of service? That was not what is in the record. This case is adjourned to 7th of October 2021 for ruling. That is what is on the record. Why should you go and put something that is not on the record?
It's Victoria that prepares constitution. It's not me, madam.
If you want to put anything, cross-check and confirm before you put it. What is the position? My ruling is ready.
My Lord, the position is that immediately we stepped out of the court, the court Kanyip issued a check to the judgment, the claimant, my Lord.
Call the case. Call the case.
Suit number NICN CA 27M 2017 between Sunday Neri Udofia and Pamo Nigeria Limited and First Bank PLC. My Lord, parties are all absent.
Appearance.
My Lord, with respect, if you look is my name, sir. Assistant Chief Legal Officer. My Lord, my appearance is for the claimant.
Any other appearance?
No, my lord.
Yes, what is the position?
My lord, based on the event that took place on the last joint date, my lord will be applying, sir. The garnishing on background of Nigeria to be distracted.
Yes.
My lord, that's all.
I have listened attentively to the submissions of counsel, intimating the court that the Ghana First Bank of Nigeria PLC had, after the last sitting of the court, issued a check to the judgment creditor in satisfaction of the judgment sum. In view of this development, the Ghana First Bank of Nigeria PLC is hereby discharged, and the Ghana proceeding hearing is hereby struck out.
As a proper. My lord, we are very-
Yes? Which one is your own? What's the case now?
Suit number NICN CA 21 2021. between Mr. Udo Isan Apa, trading under the name and style of Isanti International Enterprise, and 1. Udwak Akpan Ubang, 2. Akpan Ubang Umar. My Lord, the claimant is in court, defendant absent.
Yes, appearance.
Respectfully, my lord.
Yes.
F.S. Adeleye.
F.
Adeleye. My appearance is for the claimant applicant.
Yes.
My lord, we have a pending application. The motion dated 23rd of July 2021. Subject to the convenience of the court. Right?
What is it about?
The
Yeah.
expert application was completed by this matter on the second defendant.
What happened?
The ability for the court were able to serve the second defendant. I believe I filed an affidavit of non-service.
What he said is he could not locate. It's not that he's not in that he's not in the address. What it means, you do not provide the appropriate address of the defendant.
My lord, the address, that was the last one I got.
Yes, sir?
That was the last one.
Have you served him with the originating summons, where with the originating process complaint? In your application, look at the order, how you couch it, an order for substituted service of the summons. Is this summons you are serving him? Motions and any other court process arising from this suit. No, that is not what you said. You commence this suit by way of complaint. So if you are if you are applying to do substituted service, you say an order for substituted service, you state originating process, or you say for the complaint, not summons, because originating court process is not summons and it's not motion. And when you say any other court process, it means subsequent processes that you file. So it means you are excluding the main thing that will commence the action. So what do you want? Don't waste my time. I have cases waiting for me. Yes. What do you want now? Give me this. Okay. This case is adjourned to 3rd of November 2021 for hearing of the motion as part. What's the next case?
Number NICN.
Sorry.
103/2019 between Mr. Liche Ya Banese Monde Ibrahim and Femas British School. My Lord, parties are absent.
Appearance?
May it please the Honorable Court.
Yes.
I am CEC in Joku.
CC in Joku.
CEC initials, my lord. CEC in Joku. Joku is spelled NJOKU.
Yes. Are you appearing for who?
I humbly appear for the claimant, my lord.
Any other appearance?
It appears the
Any other
defendant is
appearance?
unrepresented.
No
None, my lord.
representation for the defendant?
Yes, despite service of hearing notice, my lord.
I'm seeing some counsel online.
Yes, my lord, and I've not seen the defendant counsel. He was present on the last date.
Okay.
Yes.
This matter is for judgment. The judgment is ready.
As the court pleases.
The judgment will be read now shortly. This is the judgment of the court. The claimant brought this action as per his paragraph 29 of the amended statement of facts sought for the relief stated below. They are, I have captured the reliefs. I don't think it's necessary to be reading them. They have been reproduced, so counsel will have opportunity of reading them when they get the hard copy of the judgment. In proving his case, the claimant testified as CW1. After identifying his witness statement of oath, he adopted it as his evidence in this case. He also tendered some documents and they were admitted in evidence and marked accordingly as CWA to CWD, CWA to CWI, to CWD, sorry. The claimant was cross-examined by the counsel for the defendant. Thereafter, he was discharged. The defendant, upon being served with the originating court processes, commencing this suit, filed on the 26th day of July 2019, filed Memorandum of Appearance and Statement of Defense. The statement of defense was accompanied by witness statement on oath and photocopies of documents to be relied on at the trial. In proof of its defense, the defendants called two witnesses, the accountant and the second defendant, who testified as DW1 and DW2 respectively. The witnesses adopted their written addresses, their written statement on oath, and as their evidence in this case. 3 documents were tendered through DW2, and they were all admitted in evidence. They were marked as exhibit DW2A, DW2B1 to 3, and DWC. The witnesses at the end of their evidence in chief were cross-examined by counsel for the claimant. The account of the facts that made the claimant to institute this action, as can be gleaned from the processes filed by the claimant and the evidence before the court, are that the claimant was by the letter of 21st day of April 2016 employed by the defendant as an art teacher. The claimant's employment took effect from 2nd day of May 2016 with consolidated salary in the sum of 127,600 naira. Upon resumption of duty and due to lack of accommodations, the claimant stated that he kept his belongings in the staff room pending when he was able to save enough money to rent an accommodation. The claimant stated that he discharged his duties, his teaching duties, diligently without any query as to the quality of his services until sometimes in July 2018 when he was issued with a temporary suspension. According to the claimant, before July 2018, when he was suspended, the defendant has developed the habit of indiscriminately owing the claimant and other staff salaries without any explanation as to its reason for doing so. The non-payment of claimant's salary has put the claimant in a difficult position as a family man. The claimant had to resort to borrowing from friends but despite the difficulty faced, the claimant continued to discharge his duties until in July 2018, when some aggrieved staff of the defendant protested the non-payment of their salaries by the defendant. The claimant neither participated in the protest nor supported it, nor did he engage in any conduct whatsoever as would situate him to the reason adduced by the defendant in suspending him and purportedly terminating his appointment. That's why the claimant was surprised to receive an email from the director of the defendant terminating his appointment. At no time the claimant was invited for representation on the allegation of his participation or role involvement in the protest. The defendant did not afford claimant opportunity to be heard before his employment was purportedly terminated. It is the case of the claimant that prior to termination of his employment, he was not paid his salaries by the defendant for a period of 9 months. The months the claimant was not paid salaries were April, May, June, July, and 2017, and April, May, June, July, and August 2018. The defendant terminated Claimant's employment without 3 months notice, nor payment of 2 months salary in lieu of notice as provided by the condition of service. The claimant also stated that all his belongings, valued at the sum of 200,000 naira, had been carted away from his office. The claimant also discovered that all the deductions made from his salaries for the 19 months he served the defendant meant for tax and pension were never remitted to the relevant authorities that are to receive the said deductions. The defendant, in response to the claims of the claimant, stated that the employment of the claimant with the defendant was terminated on the 9th day of August 2018. It also denied ever allowing any member of its staff to live in the staff room of the school or leaving his belongings in the said staff room. The defendant also stated that whenever there is delay in payment of salary to staff due to unfriendly economic situation in the country, the members of staff of the defendant were politely informed about the situation and plead with them to be patient as their salaries would be paid as soon as possible. The defendant stated that contrary to the claim of the claimant on non-participation in protest by the claimant was the team leader and he participated fully in the protest and was visibly seen in every scene of the protest in early July 2018 in the school. The defendant further stated that the claimant, alongside the other members of staff who described themselves as distressed staff, wrote a warning letter to the director of the school, thereby threatening his life and that of his family. They also promised to shut down the school. They wrote anonymous warning letter to parents via text messages, and that they are members of the fraternity cult group called Black X. The defendant also stated that they dragged the school pupil into the protest, wrote petition to Labor and the Quality Assurance Department of Ministry of FCT Abuja. The distressed staff disclosed their identity in the letter they wrote to the Labor with claimant as one of them, that the defendant, seeing the bit-by-bit execution of the warning letter by the said distressed staff, which the claimant is leading, the defendant quickly suspended them from the service of the defendant to arrest the damage and possible injury to the school, its staff, pupil, and parent. The defendant stated that the school management held several meetings with stakeholders after the staff were suspended, deliberated on the matter, and concluded that for the security of lives and property in the school, its staff, parents, and pupil, it will be very dangerous to allow suspended staff who belong to fraternity cult group Black X to be anywhere near the school. It was averred that the act of the claimant is misconduct, which by the staff handbook and condition of service, the defendant reserves the right to summarily dismiss its staff. It was also averred that the act of the claimant and his shutting down of the school caused the defendant grievous damage, which resulted in the defendants losing 180 children who were pulled out of the school, and that the act prevented prospective parents from bringing their children to the school. It was stated under the condition of service, the claimant on suspension is not entitled to salary. The defendant stated that the claimant worked for the school for 26 months, May 2016 to June 2018. The defendant has stated that the claimant's monthly salary as 127,600 naira, with 23,489 being deducted monthly as tax, 8,221, pension contribution 10,208, and 5,000 for feeding, which the staff enjoyed from the school. The defendant stated the dependent monthly salary is the sum of 104 naira 111 naira, which the claimant was paid for 19 months, with some overpayment and few underpayment. The defendant also stated that the claimant received salary advance in the sum of 39,000, 12,000 in May 2016, 7,000 in October 2016, and 10,000 on 5th of June 2017. It was stated that the claimant, though being owed 7 months salary, is only being owed 574,263 naira 23 kobo for his being overpaid for the months of May, September, October, November, and December 2016, January, February, March, August, September, October, November, December 2017, and January, February, and March 2018. The defendant counterclaimed in the sum of 100 million naira for causing huge loss to the defendant and damaging reputation. In reaction to the statement of defense, the claimant filed a reply wherein the claimant insisted that his employment is still subsisting, having not been legally and properly terminated. The submissions of the defendant formulated 5 issues for determination. They are: 1, whether determination of the claimant's appointment was proper and in accordance with the condition of service. 2, whether the claimant was paid. 2, whether the claimant was paid his entitlement according to evidence laid at the trial. 3, whether taxes and pension contribution are payable to the claimant by his employer. 4, whether the claimant was entitled to notice of termination or salary in lieu. 5, whether counterclaims not defended and or opposed by the claimant should be granted. I have in the body of the judgment reproduced the argument in respect of the 5 issues. So counsel will have opportunity of reading the submission. I will skip reading the submission. Then I goes to the submissions of the claimant. The claimant formulated 2 issues for determination. They are: 1, whether considering the facts, circumstances, and law relating to this suit, the defendant could be held to have defended the suit of the claimant. 2, whether the claimant has proved his case on the balance of probability and upon preponderance of evidence and will sufficiently influence this honorable court into granting the phrase contained on the page of the amended statement of facts. The argument also on these issues have been captured in the body of the judgment, so I will skip reading the submissions. There is a reply that was filed by the counsel for the defendant. The argument on the reply also has been reproduced in the body of the judgment. I now go straight to the decision of the court. I have considered the processes filed in this suit the evidence in chief, and under cross-examination of witnesses that testified, as well as the oral adumberation of counsel on the final written addresses filed before the court. The defendant, in its final written address, formulated 5 issues for resolution, while the claimant formulated 2 issues for resolution. Having regard to the evidence and the reliefs being sought, I am of the view that these issues can be compressed into 2 broad issues that I believe can resolve the dispute submitted by the parties. The issues formulated by the court are: 1, whether by the evidence adduced before the court and the circumstances of this case, the claimant proved entitlement to any of the reliefs being sought. 2, whether the defendant counterclaimant has proved entitlement to the counterclaim in paragraph 28E of the statement of defense. Before proceeding to determine the above issues, twin issues identified, I shall deal with preliminary issue raised by the claimant in his final written address, which is on whether the defendant failed to defend the claimant's suit due to the amendment of pleading. The counsel for the claimant is of the view that the defendant ought to have amended his statement of defense and all the accompanying processes following the amendment of the statement of claim on the statement of facts. The counsel for the claimant considered the failure of the defendant The counsel for the claimant considers failure of the defendant to consequentially amend its amendment as amounting to or refusing to defend the case of the claimant. The standpoint of counsel for the claimant was predicated on the principle of law that once there has been an amendment of pleading, the previous pleading do not count. The court only determined live issues to be tried by the court. Counsel argued that with the great In response, counsel for the defendant submitted that the defendant has sufficiently defended the claimant's case in this suit. Counsel considers submissions of counsel on non-amendment of defense as an attempt to mislead the court. According to counsel, the principle of law that the principle of law that postulates once pleading is amended by order of court, what stood before amendment is no longer material, only applies to the pleading already amended. It is also argued that even if the defendant is required to amend the defense statement of defense, failure to do so in the circumstance of this case is not fatal, since there is a counterclaim, which in law is an independent action. The law is well settled by a plethora of authorities granted by this court. It goes back plethora of authorities. Once an amendment is granted by the court, it goes back to the time when the process amended was filed. This means an amended pleading takes effect not from the date when an enactment was made, but from the date of the original pleading that was amended. Therefore, once an amendment is allowed, the amended pleading is deemed to relate back to the date of the original pleading, which it amended. In the instant case, the amendment granted on 23rd day of January 2022, when therefore the amendment granted on 23rd day of January 2022 relates back to the 8th of July 2019 when this suit was commenced by the claimant. Consequently, the grant of amendment in this after defense has filed means the statement of facts and witness statement on oath as amended becomes the processes filed at the right of the file at the origin of the action, and the claim endorsed thereon replaces the claims originally filed. Therefore, such an amendment is retrospectively regarded and deemed to have been made at the date the original pleading was filed. See the cases of Gawon versus Ike Okongu, Enai Bokan versus AICO, it is clear to me that there is no law that compel a party to amend his processes simply because his opponent has amended his processes. There is no obligation placed by the law on the defendant in this case to amend his processes. The decision to amend or not to amend is that of the party, as he is the owner of his case. He has the discretion to determine what to do with the case. The statement of defense and its accompanying processes filed in defense constitute the defense processes to be considered Therefore, such an amendment is retrospectively regarded and deemed to have been made. The statement of defense and its accompanying processes filed in defense constitutes the defense processes to be considered in the defense of the case, since the claimant's amendment has by law been retrospective. Has been retrospective dating back to the date this suit was commenced. The claimant is therefore wrong to argue that there is no cognizable defense before the court simply because the claimant has amended his statement of claim and witness statement on oath. The submission of counsel was based on misconception of law, and the same is hereby discountenanced. Going to the main issue for determination, the counsel for the claimant has argued that the claimant has not adduced sufficient evidence Coming to the main issues for determination, the counsel for the claimant has insisted that it has proved its case and entitled to the claims before the court. The claimant it also maintained that is entitled to the relief sought. It is argued the termination of claimant's appointment based on misconduct without giving the claimant opportunity of being heard amount to wrongful, unlawful, and illegal termination, and therefore the claimant's employment subsists and is entitled to payment of salaries for It is also the case of the claimant that he is entitled to arrears of salaries and deductions made from his salaries for pension, and taxes, which have not been remitted to the appropriate authority. It is apparent from the straightforward facts of this case that the claimant's case borders on validity of termination of employment by the defendant as accountant, as contained in Exhibit D. He is also claiming payment of arrears of his unpaid salaries, deductions from pension and tax, as well as other claims for damages. The law is tried The law is tried that where an action is for determination of validity or otherwise of termination, dismissal, or retirement, two fundamental issues are called to action. They are whether the termination, dismissal, retirement, and all claimants reply in addressing the issue whether termination of claimant's employment was validly done by the defendant, the claimant who claims that his employment was not properly terminated has the bounden duty of placing before the court the terms of contract of employment and then go on to prove in what way the said terms were breached by the employer. The employer has no duty of proving entitlement to them to the terms of the contract or employment between the claimants and the defendant and how they were breached. The principles applied apply to statutory employment as well as master and servant employment, or what is known as contract of service at common law at CRG versus Charge Basin Development Authority. See also Iwuchukwu versus Uwizo. The law is right that one claimant allege or claim that his employment was not determined in accordance with the terms and conditions of service, the parties, if it is for the claimant, must the law is right that where claimant allege or claims that his employment was not determined in accordance with the terms and conditions of the contract of service between him and the defendant, it is for the claimant to plead and prove conditions of service regarding the contract of service in question. The rationale behind this principle is that contract of service it is only where the terms and conditions governing contract of service are not clear or ambiguous that a court of law can move out of them and involve the general rule of contract applicable to the nature of the contract of service. See the case of Calabar Cement and Company Limited versus Daniel, reported in 1991 for Nigerian Penal Report Part 188, page 750. It is also settled that apart from any statutory provisions governing contract of service, any question as to duration of the employment, its terminability by notice, the length of notice, or the time at which notice to determine may be given, will depend on the looking at the reliefs being sought by the claimant, which have been reproduced in the earlier part of this judgment, and the evidence adduced before the court, Exhibit B, letter of offer of provisional employment dated 21st day of April 2016, and Exhibit DW2A, the handbook and conditions of service, the claimant was employed by the defendant, and the terms and conditions of employment were as depicted in Exhibit B and Exhibit 2 DW2A, respectively. Therefore, in determining the validity of the claimant's employment as contained in Exhibit D, this court is to be guided by the two exhibits, i.e. Exhibit B and Exhibit DW2A. The claimant by the Exhibit C, dated 3rd day of July 2018, was temporarily suspended pending investigation into the roles of all teachers in the action that resulted in examination being unable to be administered by the management on 3rd of July 2018, and the claimant was barred from entering the premises of the defendant as from 4th of July 2018. The letter of suspension stated that the claimant is welcome to talk to senior management at any time about the claimant's role on the event of 3rd of July 2018, after which the suspension may likely be lifted. The claimant vehemently denied participation in protest or any act that will situate him to the reason adduced by the defendant in suspending him and terminating his appointment. The claimant averred that he was surprised to receive an email from the director of the first defendant, purportedly terminating his employment as per Exhibit D. The claimant also stated that at no time did the defendant invited him for representation with respect to allegation of his purported role involvement in the protest. The claimant stated that he was not afforded opportunity of being heard before termination of his employment with the defendant. It was also the case of the claimant that he was not given 3 months notice for termination or as required under the contract of employment as contained in the provisional letter of employment, Exhibit B, nor was he paid 2 months' salaries in lieu of notice. It is in response to the defendant stated that the claimant, alongside other staff who described themselves as distressed staff of the claimant, wrote petition, a warning letter to the director of the school of the defendant, threatening his life and the life of his and that of his family members. They also wrote an anonymous warning letter to parents via text messages and claim to be members of fraternity cult group called Black X, and stating that the director is endangering his life and that of his family by playing with them. The counsel for the defendant insisted that the claimant has violated the provisions of condition of service exhibit DW2A contained in page 13 and 14 of the handbook and condition of service, which deal with termination of employment, and submitted that the defendant has the right to summarily dismiss his employee on any of the items of misconduct stated therein. It is submitted by counsel that any of the misconduct enumerated may warrant the defendant to instantly terminate an employee's appointment. Counsel has urged the court Counsel has argued that DW1 and DW2 have testified that the claimant was visibly seen in the protest within the premises. Before I go further in considering whether the termination of claimant's employment by the Exhibit D was proper or not, I shall correct the confusion in which the counsel for the defendant found himself in with respect to the terms termination and dismissal. The counsel for the defendant has contended in his final written address that the use of terms termination or dismissal does not matter. It is immaterial whether the letter stated termination or dismissal. What matters is the reason advanced in the letter bringing to an end the claimant's employment. Let me outrightly say that our labor jurisprudence make a distinction not just between termination and dismissal, but also as between wrongful termination, wrongful dismissal on the one hand, and unlawful or void termination stroke unlawful or void dismissal on the other hand. See the case of Alhaji MK versus First Bank of Nigeria PLC, reported in 2011 LPLR 8971, where His Lordship of Wanya JCA says as follows. Termination or dismissal of an employee by the employer translates into bringing the employment to an end. Under a termination of appointment, the employer is enabled to receive the terminal benefit under the contract of employment. The right to terminate or bring an employment to an end is mutual, in that either may exercise it. Dismissal, on the other hand, is punitive and depending on the contract of employment, very often entail a loss of terminal benefit. It also carries an unflattering opprobrium to the employee. See also the case of CBN and another versus Mrs. Ngozi Iguilo, reported in 2007. LPLR 835SC, also reported in Nigerian Ukilolo Report, Part 1054, and also Supreme Court Judgment, Part 4, Volume 4. In Irem versus Obubra District Council, the Federal Supreme Court recognized the distinction between termination and dismissal and held they were not intended to be used as synonymous words in law. Also, in Calabar Cement Company Limited versus Daniel, reported in 1991 for NWLR Part 188, page 750, the Court of Appeal stated that it is settled practice that the two provisions for dismissal and termination of a contract of employment operate independently of each other. It appears to me that the confusion surrounding the distinction between termination and dismissal is because all imply removal from a particular employment. On the accepted general legal principle of law, an employee may be summarily dismissed without notice and without wages if he is guilty of gross misconduct. See the case of Babatunde Ajayi versus Texaco Nigeria Limited and others. And gross misconduct has been identified as a conduct that is of grave and weighty character to undermine the confidence which should exist between an employee and the employer, so also working against the deep interest of the employer amount to gross misconduct, entitling the employer to summarily dismiss the employee. A careful perusal of Exhibit D will show that the termination of employment of the claimant was predicated on the reason stated therein, though the law does not require reasons to be given or given for termination. The employer stated reason for termination of his employment the employment stated reason for termination has imposed a burden of having to prove or justify the reason given for termination. The claimant having denied involvement in the act that culminated in termination of his employment, the onus is now cast on the defendant to prove that the claimant did deserve to have his employment terminated. See Kuleb or see Sanya versus AfriBank PLC. See also Olarewaju, SPDC versus Olarewaju. The defendant in justifying the action relied heavily on the provisions of conditions of service, Exhibit DW2A, part page 13 and 14, which deals with termination of employment. From the evidence before the court, the claimant has served out his 6 months probation, though there is no any evidence to show that upon completion of termination, the defendant in justifying the action relied heavily on the provisions of conditions of service, Exhibit DWA, page 13 and 14, which deals with termination of employment. From the evidence before the court, the claimant has served out his 6 months probation, though there is no any evidence to show that upon completion of his 6 months probation, the employment of the claimant has been confirmed. However, the fact that evidence before the court has shown that the claimant has served for almost 2 years goes to show that the employment of the claimant is in law deemed to have been confirmed. See the case of OAU versus Oshibanjo. This means that the claimant is a confirmed officer of the defendant. Going by the provisions of Exhibit DW2A, conditions of service of the claimant being a teaching staff and a confirmed one is entitled to the notice. However, there is a provision in accordance with the staff disciplinary policy, which states that the defendant reserves the right to summarily dismiss or terminate employment of a confirmed staff. The defendant, on the authority of this provision of the handbook and condition of service, stated thus: termination of the employment A careful perusal of Exhibit DW2A, the handbook and condition of service of the defendant, may decide to terminate claimant's appointment by giving him one full-term notice for termination or payment of salary for the period of notice. However, in the case at hand, the defendant decided to summarily terminate the claimant's employment on ground of gross misconduct. In such a situation, where the defendant decides to terminate on ground of misconduct, the employer is by law required to justify the reason given for termination. See the case of AfriBank Nigeria PLC versus Osi Sanya, where an employee is being removed or his service is being dispensed with for misconduct. The employee shall be given adequate opportunity to offer explanation about his conduct or defend the alleged misconduct. This requirement applies both to statutory and master and servant relationship. See the case of Olatu Bosun versus NISA. See also the case of Tayo versus Kingsway Stores Limited. The requirement of hearing stems out from the principle of eternal or divine justice, which at the common law is referred to as out the alteram pattern. In Olatum Bosu versus NISA, a show JSC of blessed memory says, and I quote, once misconduct is alleged, there must be the element of hearing. The right to fair hearing will only arise where there is allegation of misconduct, which may result in fact did result in some form of punishment, deprivation of some rights, or loss of means of livelihood. It is clear once allegation of misconduct is made against an employee, the employee can no longer possess the right to terminate by giving notice. The loss of right to terminate by giving notice has conferred on the employee the right to be entitled to fair hearing. This could be achieved by either issuing query this could be achieved by either issuing query or granting oral hearing to the employee to hear his side of the story. The defendant relies on Exhibit DW2B 1 to 3, and that the Exhibit DWC cannot be of any assistance to the case of the claimant, for the simple reason that The first document cannot be of any assistance to the case of the defendant for the simple reason that the first document, Exhibit 2 DW2B 1 to 3, was made a month after the termination of claimant's employment as per Exhibit D, while the remaining two documents on that exhibit is a petition that was authored and submitted on the day the claimant's employment was terminated by Exhibit D. Therefore, these documents are not relevant These documents are not relevant in the determination of the reason advanced in Exhibit D for terminating claimant's employment, because as at the time the defendant decided to terminate the claimant's employment, they were not available for consideration by the defendant. The defendant in the letter of termination alleged that the claimant employment was terminated following his refusal to negotiate amicably with the school management to resolve the issue of his outstanding salaries, and the involvement in writing anonymous letter which contained threat to life of the director. The claimant was accused of involvement in the marketing of the defendant and causing embarrassment to the school by posting negative write-off in the social media, as well as making phone calls to parents to remove their children from the school and constituting himself into trade union. The management in terminating claimant's employment also took into consideration the role played by the claimant in destructive and disruptive demonstration. It is clear from Exhibit D that the claimant's employment was terminated based on allegation of misconduct. This means the claimant is entitled to be given fair hearing it is one of the reasons contained in Exhibit D that led to termination of claimant's employment is the purported text message sent to parents by the claimant and the phone calls to parents by the claimant, asking them to remove their children from the defendant. However, the defendant did not tender the purported text message sent by the claimant, nor called any of the parents to testify on the text messages and the phone calls already made on them. In the circumstance and in the face of claimant's denial of sending any text message to parent or putting up telephone calls, it is also in the evidence adduced by the defendant that the claimant was said to have written letter of threat to the director of the school, but no such letter was tendered. The abandonment regarding the said threat is hereby discountenanced for lack of proof. There is also the claim that the claimant made negative posts in the social media, but no such posting has been tendered before the court. There is no evidence before the court to show the claimant was afforded opportunity to react to these allegations leveled against him in XBC letter of suspension. It is pertinent to note that suspension of claimant was dated 3rd of July 2018 to take effect from 1st July 2018. And as from 1st July 2018, the claimant was barred from entering the office premises and by the Exhibit D letter of termination of appointment. The abandonment in paragraph 11 of the statement of defense, where it was about that the management of the defendant held several meetings with stakeholders after the suspension of the claimant and his colleagues, deliberated on the matter and concluded that the security of lives and property is paramount and that it would be dangerous to allow the it will be very dangerous to allow the suspended staff who belong to the fraternity group Black S to be anywhere near the school. Further support the position of the defendant that did not afford the claimant opportunity to state his own side of the story. The requirement of the law could have been met by mere issuance of query letter. Issuance of query to the claimant and receipt of reply. The decision of the defendant on whether it is satisfied or not satisfied with the reply or explanation offered on the allegation in question would be final. In the case at hand, the defendant did not discharge its responsibility of according fair hearing. See Imonike versus Unity Bank PLC. One other laughable reason given by the defendant is that although there is no law that has made it compulsory for anybody or person to compromise his entitlement. Although the matter of employer is in case there is no law that made it compulsory for anybody or person to compromise his entitlement. Although the master or employer in this case, the defendant has in law absolute unfettered power to summarily terminate or dismiss the claimant. For such termination to be valid, valid and proper, the defendant must justify the action taken by proving the reason adduced with concrete, credible evidence. At the time the defendant met with the stakeholders and decided to terminate claimant's employment, in view of the foregoing and circumstances of this case, the termination of claimant's employment as per Exhibit D was wrongful in that the defendant has not justified the reason adduced for termination. Secondly, the defendant is not allowed in law to terminate claimant's employment retrospectively. Thirdly, the defendant did not give the claimant opportunity of being heard. See the case of Underwater Engineering Company Limited versus having determined the appropriateness or otherwise of the termination of claimant's employment, I shall now turn to the second question, i.e., what is the where the termination of employment was found to have been wrongful, the remedy available to the claimant is an award of damages. It is also pertinent to note that the mere fact that there is a finding that the termination of employment was wrongful does not mean or translate to the employment subsisting or the law is well settled that even where termination was found to have been wrongful, the termination will nevertheless be effective to end the employment relationship between the parties. See Olatu Bosun versus Nisa Sufra. Therefore, this court cannot, in the circumstance of this case, hold that the employment of the claimant still subsists and grant salary till date of judgment and continuation of payment. The law is settled that failure by the employer to follow procedure before employee's contract of service is terminated by his employer only makes the employment liable to damages for the breach of the contract and no more. CZD versus River State Civil Service Commission. It has been settled by a long line of decided cases that in cases of ordinary contract of employment where the terms and conditions of service have been provided for a specified period of notice before termination or payment of salary for the relevant period in lieu of notice, the only remedy available to an employee whose employment has been wrongfully terminated is award of salary for the period of notice and for the period of notice and other judgment entitlement. And other legitimate entitlements due to the employee at the time the employment was abruptly brought to an end and he got no more. See Kato versus CBN. See also Western Nigerian Development Corporation versus Abimbola. See also Nigerian Produce Marketing Board versus Adewumi. See also Chukuma versus Shell Petroleum. In such cases, award of general damages is inappropriate. Likewise, the employer is not entitled to be in such cases, award of general damages is inappropriate, like the employee is not entitled. Likewise, the employee is not entitled to degree of reinstatement or an order that he is still in service of his employer. The rationale behind this proposition of law is based on the fact that a servant cannot be imposed by the court on an unwilling employer, and an employee whose appointment is terminated or dismissed cannot in law reject such steps taken by the employer and regard his employment as still subsisting. See Wayek versus Oshinebo. See also Union Beverages versus Ola B. C Union Bank versus Nigeria, C Union Bank of Nigeria versus Ugbo. C Onalaja versus Africa Petroleum Limited. Applying the above principle of law to the use of applying the above principle of law to the case at hand, the claimant will in the circumstance of this case be entitled to payment of salary in lieu of notice for the period of notice for termination. The claimant will in addition be entitled to his entitlement earned as at the time of termination. See Nigerian Produce Marketing versus Adeomi and host of other cases cited therein. In Exhibit DW2AB 2A Handbook and Condition of Service at page 13 to 14, which makes provision for termination, the claimants who has no probation and who was employed as a teaching staff is entitled to be given full term notice for termination of payment of salary for the period of the full term. There is no evidence before me establishing what the period of full term is. The counsel for the claimant had stated in his final written address that the period is 4 months. This amount to counsel giving evidence, which is not allowed in law. The evidence of the claimant on payment of salary in lieu of notice is for 2 months. In the circumstances, since the claimant asked for 2 months salary instead of 4 months salary, in the circumstances, I hereby award 2 months salary as damages for the claim as damages. The claimant is entitled to for wrongful termination. The reason being that in law, a court cannot award more than what was asked for, but can grant less than what was claimed. I now turn to the claim of the claimant for his entitlement. Relief C is for an order directing the defendant to immediately pay to the claimant the sum of 29,336, being part of arrears of salary from the pleading and witness statement on oath and the evidence under cross-examination. The claimant commenced his employment with the defendant on 2nd day of May 2016 under a consolidated monthly salary of 127,600 naira. The claimant was by the Exhibit C suspended from work, and by the Exhibit D an email dated 9th of August 2018, the claimant's employment was terminated with effect from 9th of July 2018. This means that the defendant termination of claimant's employment was retrospective. This is a law wrong to terminate an employment with retrospective effect. It can only be with immediate effect or from the date when the claimant's employment was commenced with the date dependent is 2nd of May 2016. The claimant has The defendant has admitted that an agreed monthly salary to be the sum of 127,600,000, but insisted that the said amount is subject to deduction of 10,208 naira as contributory pension, 8,281 naira as tax, and 5,000 for feeding, which staff enjoy from the school. It was also stated that the claimant received salary advances from the defendant in the sum of 39,000, 12,000, 7,000, and 10,000 for different months. The defendant admitted owing claimant for the 7 months, which amount to 574,263 naira 23 kobo. This amount was after deduction of pension, tax, feeding, salary, advance, and alleged overpayment. It is pertinent to point out here that the court had, in the course of trial, entered judgment in the sum admitted. With the state of pleadings before the court, parties have joined issues on arrears of salary, deductions of pension, tax, and feeding. The law is right that he who asserts the positive has the burden of proof. See section 131, 132, and 133 of the Evidence Act. The burden of proof generally is in the sense of establishing a case virtually lies on the claimant or the initiator of a suit. If he fails to do so, his case fails. On the other hand, if he succeeds in adducing evidence to prove the fact of he pleaded, he is said to have discharged the burden of proof however, the burden of proving particular facts in civil cases, like in the case at hand, is fixed by pleading. It is not static, but shift from one side to the other, like a pendulum. The onus of adducing further evidence is on the person who will fail if such evidence is not adduced. In the instant case, claimant has the burden of establishing his salary is not subject to deductions as alleged by the defendant, and the defendant has the burden of establishing that the claimant's salary is subject to deductions which the defendant alleged must be made. Having established his employment by the defendant, the entitlement to salaries and other entitlement as per letter of employment and the same I have already, having established his employment by the defendant and entitlement to salaries and other entitlement for a letter of employment, and that he worked for the defendant up to 9th of August 2018, the burden has shifted to the defendant to prove that the claimant has been paid all his salaries and other entitlement. The Court of Appeal was emphatic in Honica Sawmill Nigeria Limited versus Hoff, reported in 1992 for NWLR Part 238, page 673, that as between an employer and an employee, as between employer and employee, the onus is on employee to prove that the employer employed him as stipulated on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the employee his salary for work done by the employee in the relevant period, but also how much the salary that he paid to the employee was. The Supreme Court has affirmed this Court of Appeal decision in Honika Sawmill. See also Nigerian Maritime Services Limited versus Apolabi. See also Osawu versus Ezianeke. See also High Grade Marine Services Limited versus First Bank. See also Bioju Nigeria Limited versus Osidacho. I have already found that the claimant served the defendant from 2nd day of May 2016 to 9th of August 2018, a period of 27 months. A period of 27 months, 7 days, when the claimant was notified of his termination. The defendant the difference in the period of service was as a result of defendant excluding the period when the claimant was on suspension. For according to the defendant, a staff on suspension is not entitled to pay. It is to be noted the suspension is a temporary interruption of service for which it could be with pay or without pay. A staff on suspension is still an employee until when his employment is dispensed with. I have read the handbook and conditions of service. Exhibit DW2A. There is no provision in it for suspension of staff. Since there is no provision for suspension without pay, the defendant cannot suspend the claimant without pay. The claimant is entitled to salary for the period of suspension. See First Bank of Nigeria versus Longe. On deduction for pension and tax, a survey of the laws governing pension and personal income tax clearly are in support of the employer deducting pension contribution and tax from employee salaries and remitting same to the appropriate authority, i.e. pension commission and Inland Revenue Services. In the case at hand, the defendant has admitted making deductions for In the case at hand, the defendant has admitted making deductions for pension contribution and tax, but there is no evidence that the deductions were remitted to the appropriate authorities. That's why the claimant in his relief G is seeking for an order directing defendant to refund to the claimant all deductions made for his pension and tax, which were remitted. Going by the law, it will be a contravention of the law to order the defendant to pay claimant monies deducted meant for pension and tax. The Pension Reforms Act imposed duty on the defendant in line with the provisions of Section 11(5) of the provisions of Section 11(5) to offer retirement saving account with the appropriate pension fund administrator where the claimant pension contribution and the employee's contribution should be paid. In view of these clear and unambiguous provisions of the law, I shall order defendant to immediately with immediate effect open a retirement saving account in the name of the claimant with any of the existing pension fund administrators. Thereafter, all deduction made All deductions made shall be paid into the said account. On tax, the dependent shall remit all the tax deductions to FCT Inland Revenue Service Commission, which is the appropriate authority to receive said payment. The deduction from feeding the defendant was asserted in the positive, in that the duty to prove it lies on the defendant. There was no evidence before me to establish that that has been the practice or it has been in the rules and regulation governing the service of the claimant. On the purported salary advance, defendant failed to tender any proof showing where the claimant acknowledged receipt of any salary advance. The defendant is in an attempt to prove this assertion has stated that at times salaries are paid by cash, or what is called table payment. EWI, in his evidence under cross-examination, stated that not all allowances in view of the finding above, the claimant is entitled to payment of salary for 27 months, 7 days for the period he serves the defendant, minus pension contribution and tax for the period of service. If the pension contribution of 10,208 naira and 8,281 naira tax deductions are deducted from the gross salary of the claimant, which is the sum of 1,200,000 and the dependent takes home pay, the claimant's take home pay would be 109,111 naira. This means claimant is entitled to the sum of 109,111 naira as salary per month for 27 months, 7 days. In order to get what the claimant is entitled to as his paid salary, the total amount that was paid to him as per Exhibit F, which amount to the sum of 2,093,622 naira 77 kobo, will be deducted from the total amount he is entitled to receive as his net salary for the period he serves the defendant, minus admitted sum. For the 27 months, 7 days, the claimant is entitled to 109,111 naira times 27 months, which will be equal to the sum of 2,971,458 naira 3 kobo. This is the net salary that, after deduction of pension and tax. From Exhibit F, the statement of account, the defendant received from the claimant the sum of 209,3622. After deducting the amount from the salary, the balance will be 877,835.56 kobo. This amount then followed by the deduction of the admitted account, which is the code has already entered judgment in respect of, that is the sum of 574,263 naira 23 kobo. If this amount is deducted from what the claimant is entitled to from the 877,000, the balance would be 303 naira On claim for club allowance, apart from the mere assertion, there is no concrete evidence to establish that this relief is not proof. The claimant has also claimed 50 million naira damages and 10 million naira exemplary damages. The law is well settled beyond peradventure that in cases of wrongful termination, the damages payable is the amount covering period of service, covering period of notice beyond peradventure, that is, that in cases of wrongful termination, the damage payable is for the amount covering period of notice and no more. The claimant, having been granted 2 months' salary in lieu of notice, is stopped from making any other claim for damages. On claim for the sum of on the 3 million naira claim for solicitor's fees, this claim being one for special damages has not been proved that it was not established by concrete evidence. It is hereby refused. It is right law that a relief which claimant is in an action is entitled to, if established by evidence, are those reliefs which form part of the claimant's course of action. Payment of solicitor's fee not being part of it is not grantable. See the case of Guinness Nigeria PLC versus Unwoke. See also Inaji versus Qualter Services Limited. The claim for solicitor's fee is not grantable as there is no proof of such. It is to be noted that the money deducted for the I now goes to the counterclaim of the dependent. The dependent issue for determination. The second issue for determination is whether the defendant has proved its counterclaim to be entitled to the money claim therein in the sum of 100 million naira. The defendant counterclaimant has the defendant's counterclaimants have strenuously argued that the claimant's dependent to counterclaim has not filed any defense to the counterclaim. In the circumstances, the court should grant the counterclaim for the failure of the from the standpoint of the law, counterclaim is an independent action and it need not to relate to or be in any way connected with the claim before the court or emanated out of the same transaction. It is not even analogous to the claim before the court. It need not to be an action of the same nature or of origin as the original claim. A counterclaim is to be treated for all purposes for which justice requires is to be treated as an independent action. From where a counterclaim relates Therefore, the counterclaim, being a separate and an independent claim, must be proved by cogent and compelling evidence. see UAC Nigeria PLC versus Eunice Akele and host of other cases cited therein. By Section 135 of the Evidence Act, the burden is on the party who denies the court to give judgment on him or any legal right or inability, whereas the law is commonplace that a claimant should succeed on the strength of his case and not on the weakness of the defendant. Therefore, the onus is upon him to prove to the satisfaction of the court the assertion made in his pleadings contained upon which he meets his case. Where a claimant failed to discharge the onus of proof upon him at the close of pleadings, a defendant is not obliged to adduce any evidence or a rebuttal. See Olowo versus Olowo. See also Nasir versus Benini. See Wolokim versus Goody. A survey of the decided cases on counterclaim have indicated that a survey of decided cases. This means that, like the main claim, have the main action have facts pleaded which give rise to the claim. The counterclaim must also have facts pleaded upon which the relief sought in the counterclaim are predicated. This is usually done by defendant counterclaimant incorporating abatements in the statement of defense by reference to facts to be relied on in proof of the reliefs being sought in the counterclaim. However, the defendant counterclaimant is at liberty to add additional or further facts to the facts contained in the statement of defense that have been incorporated by reference into the counterclaim. Indeed, in law, nothing stops any party counterclaiming from reproducing all the abatement in the statement of defense as the abatement relies upon in the counter affidavit. In the counterclaim from reproducing all the abatement there. It is apparent on the face of the statement of defense filed by the defendant in the instant case that the defendant did not plead any facts on the basis of or foundation of the reliefs set out under the counterclaim therein contained. I have searched the entire pleadings of the defendant. There are no abatement where the defendant claimant to counterclaim incorporated the abatement or any of the abatement set out in the statement of defense as abatement the defendant will be relied upon to sustain the relief set out in the counterclaim. In the absence of pleading to support the counterclaim, there could be no evidence to be adduced, as the law is well settled that pleading without evidence is proof amount to nothing, and evidence in the absence of pleading goes to no issue. This is because the law is right that evidence to sustain the claim reliefs in a civil case must be in line with the facts pleaded in relation to the said claim reliefs, where the relief sought in a counterclaim are predicated on my behalf, are predicated on any pleadings, on any pleaded facts, as in the instant counterclaim of the defendant counterclaimant. There is no evidence adduced in proof of unpleaded fact or facts in view of lack of pleadings to support the reliefs being sought by the defendant counterclaimant. The counterclaim has not been proved and same must be dismissed. The finding that there is no pleading incorporated for proof of the counterclaim is enough to dispose of the counterclaim. However, I shall proceed to consider the counterclaim on the merit, the facts pleaded in the statement of defense, and the corresponding evidence as contained in the witness. The finding that there is no pleading incorporated in the counterclaim is enough to dispose of this matter, but I shall consider. It appears to me the defendant counterclaimant is relying heavily on paragraph 7, 8, 9, 10, 13, 25, and 27 of the statement of defense, wherein it was asserted that the claimant, together with the other distressed staff, attacked the director of school, saying they will the defendant counterclaimant has averred to the effect that the activities of the claimant, which led to his suspension, termination of his employment with the defendant, has led to this defendant counterclaimant losing 180 pupils, and that it was the claimant sending text message to the parent that led to the parent to remove their children from the defendant, thereby causing the defendant to lose patronage and deprive it of income. Surprisingly, however, the defendant counterclaimant, apart from the oral evidence of DW1 and DW2, there is no concrete evidence adduced to establish that the defendant counterclaimant has lost this number of pupils. The defendant counterclaimant has not also tendered before this court evidence showing the names of the pupils that were enrolled in the school, those that were withdrawn by their parents or guardian, the failure of the claimant to establish by credible evidence the number of pupils in the school, out of which the 180 were withdrawn, is fatal to their case. This could have been done by tendering registers of people in the school prior to the activities of the claimant and the other alleged distressed staff, comparing it with the register as at the time of activities shortly after the activities of the claimants. I am also of the view that the claim of the defendant claimants that the activities of the claimants were I'm also of the view that the claims of the defendant counterclaimant that the activities of the claimant were responsible for its loss of income may not be correct. The reason being that before the alleged purported activities of the claimant, the defendant was not doing well. in the area of finances. That's why the defendant owed the claimant several months of salaries, unpaid salaries, which was what led to the crisis faced by the defendant that led to institution of this suit. The defendant counterclaimant has not also adduced any evidence to establish that the claimant destroyed or damaged any property. If there is any destruction which 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 court has not been told of, the defendant counterclaimant has not also adduced any evidence to establish the claimant destroyed properties. If there is any destruction, this court has not been told of those items or properties of the defendant that were destroyed. In the absence of abatement in the pleadings showing the properties destroyed, in the absence of abatement in the pleading showing the purport property destroyed, this court will not be in a position to make any assessment of damage to the defendant counterclaimant. The defendant counterclaimant has also stated that the claimant sent text messages to parents which resulted in parents fooling their children, and therefore the prospective student also could not come because of the damaged reputation. The defendant has woefully failed to adduce credible evidence to establish this assertion. The defendant counterclaimant should have tendered a personal The witnesses that testified for the defendant counterclaimant have not told this court that they saw the text messages or read it. The text messages was alleged to have been sent to parents, and the witnesses are staff of the defendant. They are not parents, so they cannot give evidence on the text messages not sent to them. I am of the firm view that the foregoing exposition clearly goes to show that the defendant has failed to prove his counterclaim of 100 million naira for loss of damages or reputation. Furthermore, a close look at reliefs 28 of the statement of claim, statement of defense, will reveal that the annex, the mixture of claim for special damages, destruction of school facilities, and the claim for defamation, i.e., damages a further look at relief 28 of the statement of the counterclaim will show that it is a mixture of special damages and claim for defamation, i.e., damage to reputation. This type of claim is bailed in that it offends the rules of pleading, requiring claim for special damages to be particularized and strictly proved. In the claim for defamation, publication is the live wire of the action. Publication of the alleged defamatory words is a fundamental element that must be established in an action for defamation. Therefore, it is sufficient if it is proved that the publication of the alleged defamatory material was made at least one person other than the claimant in such manner that it would convey the defamatory meaning, and that the person acquainted with the claimant understood it to refer to him as such. The text message complained of in the instant case, even if it contained libelous words, was not established. The absence of the words or writing amounting to defamation is fatal to the counterclaim. The absence of proof of publication of the defamatory materials also shows that the claimant counterclaim, the claimant defendant to counterclaimant is not liable to damages, is not entitled to damages for defamation or for refutation to warrant grant of such liable. See the case of Onu versus Agbese, Inserim versus Inserim. It is clear to me that on the broad but fundamental perspectives, the evidence laid is in respect of the counterclaim is incapable of proving the said counterclaim, having regard to the state of the pleadings of the defendant counterclaimant, quite apart that it is inadequate and too general. Such evidence must be discountenanced as it goes to no issue. See George versus Dominion Flour Mills. See also National Investment and Properties Company Limited versus Thompson. Before I end this judgment, I would like to observe that from the facts that led to the filing of this case, this suit would have been avoided if the defendant had adhered to the requirement of Section 15 of the Labor Act, which provides that wages shall become due and payable at the end of each period for which the contract is expressed to subsist. That is to say, daily, weekly, or at the end of each month, as agreed upon, provided that where the period is more than 1 month, the wage shall become due and payable at interval not exceeding 1 month. This is because there is no taking away the fact that an employee has the right to be paid for the work done. This is imperative considering the fact that whether termination or dismissal is wrongful or not, all earnings of an employee prior to the dismissal must be paid by the employer to such an employee. See, from the foregoing and the reasons given in this judgment, the claimant succeed in fact, while the defendant counterclaimant failed woefully to prove entitlement to grant of the relief sought in the counterclaim, and same is hereby dismissed. On the whole, the order of the court is as follows: 1, the termination of claimant's appointment as per Exhibit D was wrongful for having been made to have retrospective effect. 2, the claimant is entitled to payment of the sum of 218,222 naira, being 2 months' salary in lieu of notice for wrongful termination of employment. 3, the defendant is hereby ordered to pay the defendant 222 naira, being 2 months' salary in lieu of notice. 4, the claimant is entitled to payment of his paid salary amount to the total of 603,572 naira 33 kobo. 5, the defendant is hereby ordered to pay the sum of 303,000 naira to the claimant.
I do not know if my Lord had finished delivering the judgment. My Lord, we thank you for the industry invested in the delivery of the judgment. However, in okay, thank you so much, my Lord, for the industry invested in the judgment.
Sorry. Okay.
We sincerely, can I continue?
I hope you have had the conclusion.
Yes, my Lord. Even those that I could not hear, I will apply for the CTC of the judgment.
It's all right. It will be available even on our website by tomorrow.
I will be checking, my Lord. Thank you for the industry invested in the delivery of the judgment. We sincerely appreciate that. However, my Lord, in the light of the last line of the judgment of this honorable court, the defendant who had failed to still pay salaries will be asking for cost of the suit, if it will please my Lord.
I have already granted cost.
Okay, as the court pleases, we are most grateful.
Maybe because
Thank
you
you.
have not had the entire thing.
I didn't hear. I am so grateful, my Lord. Thank you very much.
Cost has been awarded. Cost has been awarded.
We are most grateful.
Thank you. What's the next case?
All right.
Suit number NICN ABJ 109 2018 Musa Usman and Ringa Nigeria Limited. My Lord, parties are absent.
Appearance. Appearance. Which suit number is that? The suit number
109 2018. Ringats. Musa Usman.
NICN/ABJ/109/2018. Any appearance? No. Legal representation. Give me that. Is it for what? For adoption? Give me a date in December. Huh?
December.
Huh? December.
Yes,
Okay, so put it on 16. This case is adjourned to 15th of December 2021 for adoption of final written addresses, parties to be served with hearing notices. What's the next one?
Suit number NICN ABJ 110/2018 between Alemudu Adedayo Victor and all is good motors Nigeria Limited. My lord, parties are absent.
May I please, my lord?
Yes.
My name is Emmanuel Adedeji, my lord.
Emmanuel Adedeji.
Yes, my lord. My humble appearance is for the claimant.
Yes. Any other appearance?
May it please my noble lord?
Yes.
Jamiu Agoro is my name.
Jamiu Agoro.
Yes, my lord. My lord, my humble appearance is for the defendant, my lord.
Yes.
My lord,
my lord, this matter is slated for adoption of final written address.
Yes. Are you ready?
Subject to we are ready, my lord.
Yes, you can go ahead, Mr. Agoro.
Yes, my lord. Before we proceed with the adoption of final written addresses, sir,
yes,
we have a pending application, my lord.
For what?
My lord, the pending application is praying your lordship for an order extending the time within which the defendant applicant may file its final written address.
When was it filed?
My lord, it was filed on the 26th day of February 2021.
Mr. Adedeji, are you objecting?
You are not objecting, my lord.
Application granted as read.
As a call, please.
As a call, please.
Yes.
My lord, the plaintiff may want to apply for another deeming their final address as properly filed and served before we proceed.
You said?
My lord, I said the claimant may want to pray the court to deem their final written address as properly filed and served before we proceed with the adoption, sir.
Yes, my Lord.
Yes.
My Lord, we humbly apply our written address dated the 21st September 2021 and filed on the 27th September 2021 as properly filed and served on the defendant, my Lord.
Application granted as read.
As my Lord pleases.
Yes, Mr. Go.
Yes, my Lord. In view of the order just granted, my Lord, we filed our final written address, my Lord, on the 26th day of February 2021.
Yes.
Lord, by the said final written address, the defendant is praying your lordship for an order dismissing the instant action for want of merit, sir. My Lord, we adopt the arguments contained in the said final written address
Yes.
as our oral submission in support of the case of the defendant, sir. And also in urging your lordship to dismiss the instant action.
Yes.
May my Lord be pleased, sir.
Yes. Mr. Adedeji.
Yes, my Lord. The claimant filed his final written address on the 27th day of September 2021. The said written address is dated 21st day of September 2021.
Yes.
My Lord, we adopt the content of the written address as our oral argument in support of the claimant's case.
Yes.
We urge my Lord to grant all the relief sought by the claimant. May you please, my Lord.
My Lord, sir.
Yes.
Yes, my Lord. Ordinarily, I intend to put in a reply, but however, in view of the adoption, my Lord, may I humbly seek my Lord's leave to orally, within 1 minute, sir, just reply on point of law to the claimant's final written address. Just 1 minute, sir, and it's just an authority I want to cite, my Lord.
It's all right.
Okay, my Lord. My Lord, by paragraph 3.17 of the claimant's final written address, my Lord.
Paragraph
3.17. 3.17.
Yes.
My Lord, the claimant had cited an authority, the case of Sahara Energy Resources Limited versus Mrs. Olaomi Oyebola.
Yes.
My Lord, the authority was cited by the claimant in an attempt to invite my Lord to grant more than the recognized damages allowed in an action of this nature.
Yes.
Lord, by the said authority, the claimant had implored your lordship.
Yes.
And in the event that the court finds that the claimant employment was wrongfully terminated, in the event
Yes.
the Lord find out that the employment was wrongfully terminated, to grant more than the salary in lieu of notice, which we had already argued in our address that my Lord can only grant that salary in lieu as damages and nothing more. But they had prayed my Lord to grant more than that, and they cited this authority. My Lord, we are also relying on this same authority to state that the position as presented by the claimant is misconceived, sir.
Yes.
My Lord, the law as espoused in that case is clear, sir, that where a claimant is praying the court for declaration that his employment was wrongfully terminated, and if the court finds that the employment was indeed wrongfully terminated,
Yes.
the only remedy allowed or that is grantable is the salary in lieu of notice and nothing more.
Yes.
My Lord, a cursory perusal of the claim of the claimant as it is before this honorable court will readily reveal that the claimant had prayed your lordship for a declaration, particularly a declaration that the employment was wrongfully terminated.
Yes.
Was wrongfully terminated. So it is a case of wrongful termination, my Lord. The case as it is before the court is a case of wrongful termination of employment. My Lord, that authority is clear that where the case is a case of wrongful termination.
Mr. Agoro?
Yes, my Lord. Yes, my Lord.
Let us not waste time.
Yes, my Lord.
It is the claim of the claimant that will determine the kind of order that court will make.
As the court pleases.
The pleading. So don't have any fear. The mere fact that he cited the case, I will have to go through it and see. Although I have read it before.
As the court pleases. As the court pleases. My Lord, in view of this, my Lord, I also place heavy reliance on that authority, that case of that Sahara, as relied on by the claimant. And I finally, sir, urge your lordship to dismiss the case of the claimant in its entirety as being lacking in merit, sir. May my Lord be pleased.
You are welcome. This case is adjourned to 16th of December 2021 for judgment.
As a call, please.
As the court pleases, my lord. We are most grateful, sir.
You are most grateful, sir.
You are welcome.
21, 2019, between Honorable Ismaila Lawadi and 22 others, and 1, Adamawa State Government, 2, Attorney General Adamawa State, 3, Ministry of Local Government and Chieftaincy Affairs, 4, Mintika Local Government. My lord, parties are absent.
Appearance? Any appearance?
May my noble Lord be pleased.
Yes.
May my noble Lord be pleased.
Yes.
I.E. Insikan. My appearance for the claimant.
I.E. Insika.
Insikan.
Any other appearance?
May it please,
Yes.
ZY
Talk loud. Talk loud.
Usman.
I'm not hearing you. I can't see you on the screen. I can't record you without seeing you. Yes.
ZY Usman.
I said I cannot see you on the screen. You have to on your video.
It's on, my lord.
Yes.
ZY Usman.
Please, you have on so many devices. Use only one so that we can hear you. Use only one device so that we can hear you.
As a call, please. ZY Usman is my name, my lord.
Who?
ZY Usman.
Why Usman?
ZY Usman.
ZY Usman.
Senior State Council Grade 2.
Yes, are you appearing for who?
Adamawa State Ministry of Justice. I'm appearing for first, second, and third defendant.
Yes, second,
and third defendant.
And third defendant.
Yes, my lord.
Yes. Any other appearance?
No appearance.
Yes.
My lord, the case was adjourned for adoption.
It's not for adoption, it's for motion. There is a motion before me.
Yes, my lord. There are two pending motions, my lord.
Yes.
My lord, the first was filed by defendant, who is unavoidably absent.
Yes.
And we also have a motion for extension of time, my lord. That is for the first, second, and third defendant.
You can go ahead with your own.
As the court pleases. My lord, we have a motion dated the 30th day of June 2021 and filed on the first day of July 2021.
Yes.
My lord, the motion is seeking for extension of the week to file our final written addresses.
Yes.
If it pleases my lord, may I have the terms of the motion in favor, my lord?
Is crack.
My Lord, I'm not objecting.
Application granted as prayed.
We are grateful, my Lord.
Yes.
Before my Lord is the final written identification.
What of the
My Lord?
other? We have to treat all the applications.
As the court pleases, as the court pleases.
What happened to the other defendants? Why has it not been concluded?
This meeting is being recorded.
Yes.
My Lord, in view that the court defender is properly served, my Lord, he has not yet moved his motion, my Lord. We shall be urging my Lord to strike out the motion.
Iska.
My Lord,
Yes, what is your reaction?
Lord, I align myself with the submission of my limits here. Let the motion be struck out because they were properly served and the link was sent to them and they undermined this court. That's what I think.
Do you have virtual sitting next week? When? Friday.
Yes.
What of Thursday?
Thursday, yes. Normal court sitting.
Mr. Uthman and Iskak.
My Lord,
I will give them one more chance. I will give
as the
you
court pleases.
Thursday next week. If they are not here, then we can go ahead without them being present. What is
As the court pleases.
Thursday is 14, Friday is 15.
I will take it first.
Okay, ma'am.
9 o'clock. Tell Patak if it is 9 o'clock.
Yes, ma'am.
This case is adjourned to 14th of October 2021 for adoption virtually by 9 a.m. So please try to link up by 9 a.m. I will take
As a
your
copy.
test first. I will take your
As a copy.
test first. Try to link off by 9.
As a copy, we'll
9
do that,
and
man.
14th. You are welcome. Okay, thank you, Council. We have come to the end. We have come to the end of virtual sitting. Thank you very much. Administrator. Okay, you are welcome.
I even called you yesterday after sending him the link. I called him. Complaining that they are not ready. They are not mobilizing. And they are only garnishing.